Donald Trump wins big at the Supreme Court. He's staying on the ballots unless the Democrats have anything to say about it. They're working hard to remove him and remove him and remove him, but the Supreme Court said you can't do it through a state-level attack funded by people who are supporting Jenna Griswold and the Democrat efforts to rig the 2024 election. So a big historic day. Trump wins 9-0. We're going to go through the opinion and unpack it because there's a lot to this, and I think it actually forecloses some other attack vectors that the Democrats have in mind, you know, like a state resolution or like a criminal conviction. Part of the reason, in my opinion, they've been racing so quickly to try to convict Trump is because that conviction will be the execution under the 14th Amendment that will allow them to suddenly disqualify him under the insurrection clause. So we're going to go through that and then get some reaction from Garland. Psaki's very upset about the other case in front of the Supreme Court, and there's a question about whether there was actually a dissent in this opinion at the outset. And so let's take a look at the opinion itself, get right into it, because this is a very important moment in the Supreme Court of the United States. The case, of course, is Trump versus Norma Anderson, and these are the Colorado ballot removal litigants, and they were successful in the Colorado Supreme Court to get him off the ballot. And when we were here, we were so shocked that this was even an attempted maneuver because, of course, if this were to have been successful, you can imagine the domino effect. We already saw the domino effect on this. Colorado made their decision. Shenna Bellows in Maine made her decision, copied her homework. And then in, I think, Illinois, some other judge just copied Maine's homework. And all these judges are just copying each other's homework, and all with one end in mind, which is to stop Trump. But now the Supreme Court has said, enough already, you children. This is ridiculous. In a 9-0 opinion, they said Trump stays on the ballot. Here is the opinion. Now, it's per curiam, right? It's the opinion of the court. And we do see that when we just structurally go through this, we're going to have a majority opinion, and then we're going to have some concurring opinions. And some people I've heard in the media calling them dissents. They're not dissents. They are concurring opinions. And of course, Judge Amy Coney Barrett is concurring in part and concurring in the judgment. And we're also going to see some reaction from the three lefty judges, okay? Sotomayor, Kagan, and Jackson concurring in the judgment. And so we've got three different buckets that we'll talk about. All 9-0 say that Trump needs to stay on the ballot, obviously. But they have a little bit different interpretations of the scope of the ruling. And I think because Sotomayor, Kagan, and Jackson, they would actually like more removal opportunities to be available. In other words, the court here today is going to say that only federal Congress can do it. But by saying that, they're going to foreclose other attack vectors. And so, of course, the lefties are saying, well, that's not really before you here today. So what happens if another case pops up where state legislature just passes a resolution, right, that Trump committed an insurrection according to Colorado law? What if the legislature did it at a state level? Does the Supreme Court say that that's prohibited? What if Donald Trump is convicted of a crime by Judge Chutkan and the jurors in D.C.? Is that self-execution, or is that execution enough such that the 14th Amendment is now in play and Trump can be removed? So I think they wanted to keep those options open, and they're kind of not going to get that ability today, which is big, right? This is actually more expansive, I think. It protects Trump more than just the state-level ballot removal attack by private litigants and corrupt secretaries of state like Shenna Bellows. All right, now let's get into it. Enough out of me. It's March 4th. The opinion comes out of the Supreme Court of the United States. They say a group, giving us some background here, of Colorado voters, they contend that Section 3 of the 14th Amendment, the insurrection clause, prohibits Trump, former president who seeks nomination, from becoming president again. We know their arguments. Now, the Colorado Supreme Court agreed with that contention. 7 Democrats and a unanimous opinion there. Actually, it wasn't unanimous, I don't think. But they found him, I think there was a dissent there. Yeah, there were dissents. But they did find him removed, regardless. So then, from Colorado, it ordered the Colorado Secretary of State to exclude the president from the Republican ballot and to disregard any write-in votes that were cast for him. They say Trump challenges that decision on several grounds. Here they come. Because the Constitution makes Congress, rather than the states like Griswold, Bellows, and Benson, responsible for enforcing Section 3 against federal office holders and for candidates, we reverse. And so there's a big question there, right? Congress, and what's the enforcement mechanism? So it sounds like it's legislation. Let's see where this goes. Some background here. Last September, about 6 months before the March 5th, 2024 Colorado primary election, which is the day after this opinion, 4 Republican and 2 unaffiliated Colorado voters, they filed a petition against Trump. So they sued, basically, Trump and the Colorado Secretary of State, Jenna Griswold. And this is an interesting tactic that they have been doing a lot of. And we saw this all throughout 2020. It was wild. In other words, you have a third party here suing, okay, the state. So we'll call that the state here. And the idea is that this is adversarial. Okay, so a third party in this case would be the Colorado so-called voters, right? It's these private litigants who are making the lawsuit. So you generally think when you file a petition, so if it's the third parties against Crazy Eyes Griswold, you say, well, that's adversarial. They should be like opposing each other, right? Wrong. Secretary of State Griswold like totally agrees with them. Says, yeah, they should be removed. Yeah, it's great. So it's not adversarial at all, right? It's like they're just playing patty cake. So then Trump has to intervene and the Colorado Republican Party needs to intervene and so on. This happened a lot during the last election. In 2020, we saw the Retired Alliance of America, or like the Retired Alliance of Michigan. We saw them filing suits against Jocelyn Benson of Michigan. Same thing, right? We're suing you. COVID makes it difficult for seniors to vote. Rah. And Jocelyn Benson says, you're right, it does. Those signature requirements are a big burden on us. And so it's actually playing patty cake between the two of them, right? And this is how they initiate these lawsuits. So get ready for more of those. Now, these voters, whom we refer to as the respondents, the litigants, they contend that after former President Donald Trump's defeat in 2020, that he disrupted the peaceful transfer of power by intentionally organizing and inciting the crowd that breached the Capitol on Capitol Hill, as Congress met to certify the results on J6. Now, one consequence of those actions, said the Colorado people, is that Trump is constitutionally ineligible to serve as the president again. And of course, we had a question about that. How did that determination get made? What was the process by which that determination, he's ineligible? Okay, how did you get there? Show your math, right? Your teacher, you just put down 21. Okay, well, how did you get that number? Show your homework or else it doesn't count. And they just said, well, he committed an insurrection. Now, their theory turns on Section 3 of the 14th Amendment. Now, we've read this many times. Let's do it once more briefly. It says, no person shall be a senator or representative in Congress or elector of the president and vice president or hold any office, civil or military, under the United States if that person who, having previously taken an oath, shall have engaged in an insurrection or rebellion of the same or given aid and comfort. Now, Congress may, by a vote of 2/3, remove that disability. And you'll notice here that there is no president right here before this, okay? It's like senators, very powerful. Representatives, pretty powerful too. Then electors and so on. But you're missing a gaping void right here. What is that? There is no president. Even Ketanji called that out. If they meant it to apply to the president, why didn't they put that word in there? Oh, because they didn't mean it. Now, according to the respondents, the litigants in Colorado, Section 3 applies to the former president because after taking the presidential oath in 2017, he intentionally incited the breaching of the Capitol in order to retain power, which again is just wild. What a dumb theory. Like, again, how is he going to do that? Grab the podium? Now, they claim that he is therefore not a qualified candidate and that as a result, the Colorado Secretary, Crazy Eyes Griswold, may not place him on the ballot. And so she says, right, she gets this lawsuit. She's like, wow, that's great. I love this lawsuit. Sounds great. You're right. I can't. Justice requires that I investigate this, right? And so she's being sued. And it's like a third party is leveraging and maneuvering this whole thing. Now, after a 5-day trial, which is ridiculous, we covered it here, the state district court, and that was Sarah Wallace at the lower level court, she found that Trump did engage in an insurrection. She said, yeah, it's true, insurrectionist, but then denied the litigants' petition. She said, why? Well, the Section 3 of the 14th Amendment, it does not apply to the presidency because it doesn't mention the presidency by name. Right back up here is the gaping void. Sarah Wallace, even though she's like, I really don't like this guy, I didn't want to get rid of him. Even she's like, there's no president here. I can read, and decided, sorry, it doesn't apply to him. She said the president is not an officer of the United States within the meaning of that provision. Another good call, because the president is the root, right? The president is like the executive branch. And I know it's like undefined. It's like dividing by zero, right? It's this weird concept that if the president is an officer, he becomes subordinate to something. And then what is that thing? Then that thing is the ultimate power of the country. And that's not how this works. So in December, the Colorado Supreme Court reversed in part and affirmed in part by 4-3. There we go. Not unanimous, right? So it was a split, even though I think there were 7 Democrats. I think all of them were appointed by Democrats. Now, reversing the district court's operative holding. So Wallace says, sorry, Trump stays on the ballot. They come back and say, sorry. They reversed in Colorado at the Supreme Court. The majority concluded that for the purposes of Section 3, well, so they just like cobbled it in there. Well, if we're only asking about Section 3 and not other areas of the Constitution, well, just for Section 3, sure. The presidency is an office. And the president is an officer. And the court otherwise affirmed, holding that the Colorado Election Code permitted the respondent's challenge, right? So you can file this petition. Congress doesn't need to pass any implementing legislation. So it just happens like magically. It's magical insurrection fairies who just make a determination. They come and sprinkle their insurrection dust all over the crowd. And an insurrection has occurred here, and we all know. And then that's it. That's all we need. Don't need legislation. Don't need anything else. So Congress then doesn't need to pass anything for disqualifications. Section 3 just works like that. That the political question doctrine, meaning some things you can't really sue sue over, it does not preclude judicial review over Trump's eligibility, so we could hear the case, and that Sarah Wallace, the lower court, did not abuse its discretion when she just admitted all of the J6 evidence, right? It's all hearsay evidence that was compiled by a fake committee on January 6th. And I say that because they didn't even follow their own rules. They were supposed to be constituted under H.R. 503 to have split number of Republicans, 5 Republicans and 8 Democrats, I believe was the split. They didn't have that. Nancy just made it up out of nowhere and appointed 2 Republicans with 7 Democrats. Obviously, it was even illegal according to their own rules. It was not adversarial. There was no due process of law there. There was no cross-examination, nothing. It was all a fake book report from Liz Cheney. And then they shoved it down America's gullets like it was a real thing. It was not. It was even Hollywood produced and all. It was wild. So the point is, they admitted all that. They bundled it up like, this is evidence. Okay, it's a documentary. Might as well have Michael Moore produce it. That the district court did not err in concluding that those events constituted an insurrection and that Trump did engage in the insurrection and that Trump's speech to the crowd that breached the Capitol was not protected by the First Amendment. And so 4 liberal justices in Colorado ruled accordingly. They said, do not list President Trump's name on the ballot and do not count any write-in votes for him. 4 Democrats saving American democracy by disenfranchising their entire state. Nice work over there in Colorado. And then Shenna Bellows is like, I love that. I want to save democracy too. Yeah. And Illinois is like, yeah, I love democracy. So can't count any votes, right? So your whole state is disenfranchised. So Chief Justice Boatwright, Ansamore, and Birkencotter, actual people who care, each filed a dissenting opinion. Now, under the terms of the opinion of Colorado, its ruling was automatically stayed pending the Supreme Court review, which is where we're at now. And we granted Trump's petition, and it raised one single question. Trump asked this one question. Here it is. Did the Colorado Supreme Court err in ordering President Trump excluded from the 2024 presidential primary ballot? Great question. Answer. Concluding that it did make a mistake, the Supreme Court of the United States says, sorry, Jenna Griswold, we now reverse. Boom. Beautiful. So here's what they tell us. Now, we'll pay attention to these sections because Amy Coney Barrett is joining in one and not joining in the other. But they say, let's get down to it. All right. So a lot of people on the left, like Judge Luttig, Lawrence Tribe, many others on MSNBC, all their legal scholars, said this was a great case and that the Democrats in Colorado hit a home run. We're going to hear from Luttig in the next segment. But here's what the court says. This is the Supreme Court of the United States writing. Proposed by Congress in 1866 and ratified by the states in 1868. The 14th Amendment expanded federal power at the expanse of state autonomy. So when a state is challenging the feds win. And thus fundamentally altered the balance of state and federal power struck by the Constitution, whether you like that or not. Now, Section 1 of the amendment, for instance, when we study it, it bars the states from depriving any person of life, liberty, or property without due process of law and denying to any person the equal protection of the laws. Now, we talk about this in the law as incorporation, right? So the federal Constitution and the federal Bill of Rights, some of those rights weren't incorporated into the states. And so we talk about this process of incorporating those rights into the states and sort of unifying them throughout. And 14th Amendment does a lot of that here. And Section 5 confers on Congress the power to enforce those prohibitions along with other provisions by appropriate legislation. So you see how this works. Appropriate legislation would be the way that this gets executed. Now, Section 3 of the amendment, it restricts state autonomy, but it does through different means. Section 3 was designed to help ensure an enduring union by preventing former Confederates from returning to power after the Civil War. They point us to the Congressional Globe 39th District 1866. There's a statement that was made by Representative Stevens. He warned that without the appropriate constitutional reforms, quote, yelling secessionists and hissing copperheads would take seats in the House. Yelling secessionists and hissing copperheads would take seats. There was another statement from this senator, Senator Howard. He lamented the prospect of a state legislature made up of entirely disloyal elements absent a disqualification provision. So Section 3, it aimed to prevent such a resurgence by barring from office those who have taken once an oath to support the Constitution and then afterwards went into rebellion against the United States. And so they tell us, the Supreme Court writes, Section 3 works by imposing on certain individuals a preventive and severe penalty, disqualification from holding a wide array of offices rather than by granting rights at all. So it's therefore necessary, as Chief Justice Chase concluded and the Colorado Supreme Court itself recognized, that we need to ascertain what particular individuals are embraced by the provision. Now, Chase went on to explain that to accomplish this ascertainment and to assure effective results, proceedings, evidence, and decisions and enforcements are indispensable. And for its part, Colorado concluded that there must be some kind of determination, right? Some execution that Section 3 applies to a particular person before the disqualification holds its meaning. Saying the Constitution then empowers Congress to prescribe how those determinations should be made, right? So it goes to Congress. The relevant provision is Section 5. Section 5 enables Congress, subject of course to judicial review, to pass appropriate legislation to enforce the 14th Amendment. Or, as Senator Howard put it at the time the amendment was framed, Section 5, he wrote this in the Congress, or said this, that Section 5 casts upon Congress, not Jenna Griswold, the responsibility of seeing to it for the future that all the sections of the amendment are carried out in good faith. And so that is the big holding, right? Congress. Now, Congress's Section 5 power is critical when it comes to Section 3. Indeed, during a debate on enforcement legislation, less than a year after the ratification of this, there was a senator called Trumbull. He noted, he said, notwithstanding Section 3, hundreds of men were holding office in violation of its terms. The Constitution, Trumbull noted, provided no means for enforcing the disqualification, necessitating a bill to give effect to the fundamental law embraced in the Constitution. So the enforcement mechanism that Trumbull, the senator, championed was later enacted as part of the Enforcement Act of 1870. And this is pursuant to the power conferred by Section 5 of the 14th Amendment. So in other words, there's some history to that. They relied on that to pass a bill. So they passed, in other words, the Enforcement Act of 1870. Why did they do it? Well, because Section 5 of the 14th Amendment told them they could. So they know how to use it. So because they used it that way, that's how we should be using it today. Now, this case raises the question of whether the states like Jenna or Shenna or Jocelyn or any of them, in addition to Congress, and I think this is where we're going to see that there are some disagreements, whether the states in addition to Congress may also enforce Section 3. And we conclude that states may disqualify persons holding or attempting to hold state office. Okay, so they may regulate their states, but not the federal elections. But states have no power under the Constitution to enforce Section 3 with respect to the federal offices and especially the presidency. Griswold blown out. Now, in our federal system, the national government possesses only limited powers. Yeah, right. Yeah, right. We wish. Now, the states and the people retain the remainder. Yeah, they write that, but give me a break. Now, it's true, right? That's written in the law. That's a Supreme Court case, so okay. But among those retained power is the power of the state to order the processes of its own governance. In particular, states enjoy sovereign power to prescribe the qualifications of their own officers. So if you want to disqualify your own little insurrectionist over there, you can do that, but not on the national stage. And the manner of their election are free from external interference so long as they follow the Constitution. And although the 14th Amendment restricts state power, nothing in it plainly withdraws from the states this traditional authority. And after ratification of the 14th Amendment, states use this authority to disqualify state officers in accordance with the state statutes. They've already done this. They give us some examples of this. Now, such power over governance, however, does not extend to federal office holders, because federal office holders owe their existence and their functions to the united voice of the whole, not of a portion of the people. Powers over their elections and qualifications must be specifically delegated to rather than reserved by the states. But nothing in the Constitution delegates to the states the power to enforce Section 3 against federal office holders and candidates. They say, as an initial matter, not even the respondents from Colorado, not even they contend that the Constitution authorizes states to somehow remove sitting federal office holders. Well, what happens if they're already elected? Okay, what happens? Can a state just disqualify Biden right now because he's got an insurrection problem with the border, who may be violating Section 3? They say, well, can you just disqualify him? Such a power would flout the principle that the Constitution guarantees, which is the entire independence of the general government from any control by the respective states. So one state can't remove a sitting office holder under the 14th Amendment, under Section 3. Is it consistent with that principle? States lack even lesser powers, even the lesser powers, to issue writs of mandamus against federal officials or to grant habeas corpus relief to persons in federal custody, right? We get a lot of that from the Supremacy Clause. States can't conflict. Now, the respondents, nonetheless, the litigants from Colorado, they still maintain that states may enforce Section 3 against candidates, right? They're saying, well, Trump's not in office yet, and so we're just latching onto this qualification problem. That's how they prevent him from getting on the ballot. But the text of the 14th Amendment on its face does not affirmatively delegate such a power to the states. You don't have the right. The terms of the amendment speak only to enforcement by Congress, which enjoys power to enforce the amendment through Section 5. Now, Now, this can hardly come as a surprise. It is, I'm sure, for Jenna, given that the substantive provisions of the amendment embody significant limitations on state authority. It's kind of why we have them. We had a bunch of rebellious states during the Civil War. They didn't want that to happen again. Now, under the amendment, states cannot abridge privileges or immunities. They cannot deprive persons of life, liberty, or property without due process, deny equal protection, or deny male inhabitants the right to vote. Now, on the other hand, the 14th Amendment grants new power to Congress to enforce the provisions of these amendments against the states. It would be incongruous to read this particular amendment as granting the states the power silently, no less, without even writing it in the document. Weird, magical insurrection fairies, as we talked about, to disqualify a candidate for federal office. Now, the only other plausible constitutional sources of the delegation could be the elections or the electoral clauses, which authorize the states to conduct and regulate congressional and presidential elections, respectively. But there is little reason to think that these clauses authorize the states to enforce, implicitly, Section 3 against federal office holders. Granting the states that authority would invert the 14th Amendment's rebalancing of federal and state power, and that's why it was always logically idiotic. Now, the text of Section 3 reinforces these conclusions. Sorry, Judge Ludwig, should have read it more clearly. Its final sentence empowers Congress to remove any Section 3 disability, right, by a 2/3 vote of each house. Now, so this text imposes no limits on that power, and Congress may exercise it at any time. In fact, historically, Congress sometimes has exercised this amnesty power post-election to ensure that some of the people's chosen candidates could, in fact, take office. Now, this was a wild part of our history in America, and it's curious if this would ever happen again. I don't think so. But let's take a quick look. Footnote 2 says, shortly after the 14th Amendment was ratified, Congress enacted a private bill to remove the Section 3 disability of this guy, Nelson Tift of Georgia, who got elected. So, for example, do you think that if somebody ran for office in America that was, MAGA, and he was just precluded, do you think that Congress would remove that disability in this current political environment ever? Like, my point is, Congress removed Section 3 of the disability for this guy, even though apparently he was an insurrectionist. They said that's why he had that prohibition. They removed it, and then he took his seat in Congress, right? So that's like, you think Jamie Raskin and Eric Swalwell are going to get together and allow, pick some Republican to come back after they've already thrown him out? Obviously that would never happen now. And they had a civil war back then. We had 700,000 people dead. So it was a big, sort of reunification, this idea that they could even come, bring them back. Like now, Liz Cheney, she would never, ever, I think, offer an olive branch to the other side and say, can we let bygones be bygones in this new America? Never, right? It's like a blood sport now. Now, Congress similarly acted post-election to remove the disabilities of persons elected to state and local offices, right? So they also said, well, look, hey, we know it was a complicated, hot moment, but we are going to allow you, to run again after all this insurrection occurred. Give me a break. So they continue. They tell us that if the states were free to enforce Section 3, if Griswold could just bar candidates from running in the first place, Congress would be forced to exercise its disability removal power before voting begins if it wished for its decision to have any effect on the current election cycle. Now, perhaps a state may burden congressional authority in such a way when it exercises its exclusive sovereign power over state offices, but it is implausible, says SCOTUS, to suppose that the Constitution affirmatively delegated to the states the authority to impose such a burden on congressional power on federal offices. Nor have the Colorado litigants identified any tradition of state enforcement of Section 3 against federal office holders in the years following the ratification of the 14th. They say we're aware of just one example of state enforcement against a would-be federal officer. Back in 1868, the governor of Georgia, long before Big Fanny's time, he refused to commission John Christie. John Christie had won the most votes in a congressional election because, in the governor's view, Section 3 made Christie ineligible to serve. But the governor's determination was not final. A committee of the House reviewed Christie's qualification itself and recommended that he not be seated. The House never acted on the matter, and Christie was never seated. And so that's about as far as the precedent goes. The House never took any action on it, and it was never really, dealt with. That's SCOTUS, right? That's SCOTUS saying, we looked through all the history. You say this happened. You say this didn't happen. That's all we found. One example of state enforcement. And it wasn't, didn't even actually matriculate. So such a lack of historical precedent is generally, quote, a telling indication of a severe constitutional problem with the asserted power. Whoa, okay. A telling indication of a severe constitutional problem with the asserted power. 2023 case. Now, what if we take that out, that statement, and apply it to the immunity decision that we're waiting for with the Supreme Court? And you could argue that sentence both ways, right? There has been 434 years of no prosecutions against the current or former president. Because in my argument, it would be there's immunity there, right? Because nobody has decided they could do that until now. Now, they would turn that on its head and they would say, well, there is no historical precedent of immunity. So maybe that's a telling indication that it doesn't exist, So that's a very powerful sentence there that, I think we're going to see parallels between this and the immunity case. Because again, it's talking about federal power, federal elections versus the state levels. And if private actor suing a Secretary of State can't get Trump removed from the ballot, that's a state versus a Fed argument. If Fani Willis can prosecute Trump and Trump doesn't have presidential immunity by Jack Smith or any of these other, any prosecutor can then attack the federal election and usurp it in a way that I don't think the Constitution allows. So it's going to be fun to watch the parallels now. And it is an especially telling sign here because, as noted, the states did disqualify persons from holding state offices following ratification of the 14th Amendment. That pattern of disqualification with respect to state but not federal offices provides, quote, persuasive evidence of general understanding that the states lacked enforcement power with respect to the latter. Instead, it is Congress that has long given effect to Section 3. Shortly after the ratification of the amendment, Congress enacted the Enforcement Act of 1870. Now, that act authorized federal DAs to bring civil actions to remove anyone holding non-legislative offices in violation of Section 3. In the years following ratification, the House and the Senate exercised their unique powers under Article 1 to adjudicate challenges, contending that certain or prospective members or sitting members could not take or retain their seats due to Section 3. And the Confiscation Act, passed in 1862, that predated Section 3, and that effectively provided an additional procedure for enforcing disqualification. That law made engaging in insurrection or rebellion, among other acts, a federal crime punishable by disqualification, and a successor remains on the books today. We got U.S. Code, 18 U.S. Code 2383. Now, moreover, permitting state enforcement of Section 3 against feds would raise serious questions about the scope of that power, obviously. Section 5 limits congressional legislation enforcing Section 3 because Section 5 is strictly remedial. And so to comply with that limitation, SCOTUS continues, they say Congress must tailor its legislative scheme to remedying or preventing the specific conduct the relevant provision prohibits. Here, Section 3, unlike other provisions of the 14th, proscribes the conduct of individuals. It bars persons from holding office after taking a qualifying oath and then engaging in an insurrection or rebellion. Nothing more. Any congressional legislation enforcing Section 3 must, like the Enforcement Act of 1870 and the current U.S. Code, it must reflect congruence and proportionality between preventing and remedying that conduct and the means adopted to that end. So neither we nor the respondents are aware of any other legislation by Congress that was passed to enforce Section 3. So we're going to pay close attention to this because Jamie Raskin, Eric Swalwell, and the others, they're roaring right now. They are already drafting literal legislation to stop Trump in the aftermath of this opinion. Any state enforcement of Section 3 from a state, though, would not derive from Section 5, which confers power only on Congress. And so as a result, such state enforcement might be argued to sweep more broadly than to congressional enforcement. But the notion that the Constitution grants the states more power than Congress to decide how this should be enforced is simply implausible. Now, finally, state enforcement of Section 3 with respect to the presidency would raise heightened concerns. In the context of a presidential election, state-imposed restrictions implicate a uniquely important national interest. But state-by-state resolution of the question about whether Section 3 bars a president from serving would be quite unlikely to yield a uniform answer. And the president represents all the voters of the nation. And so, conflicting state outcomes about the same candidate could result not just from differing views of the merits, but from variations of state law and from various different governing procedures. Some states might allow a Section 3 challenge to succeed based on a different standard called preponderance of the evidence, that lower standard we talk about. Others might require a heightened showing. Certain evidence, like the J6 fake report, on which the lower courts relied here, some states might admit it, others might not. Disqualification might be possible only through criminal prosecution, as opposed to expedited civil proceedings in particular states. Indeed, in some states, unlike Colorado or Maine, where the secretary also issued an order excluding Trump, Shenna Bellows copied Jenna's homework. They don't like to do their own work. I think that looks good enough. Send it over. Procedures for excluding an ineligible person from the ballot may not exist at all. So the result could well be that a single candidate would be declared ineligible in some states, but not others, based on the same conduct. And we'd have like a civil war. I mean, it's like a soft civil division. Trump doesn't win because a bunch of states didn't even vote for him. Okay. We didn't get to participate in our election. That's the end of it. So the patchwork that would likely result result from state enforcement, if we allowed it, would sever the direct link that the framers of the Constitution wanted that was so critical between the national government and the United States. But in a presidential election, the impact of the votes cast in each state is affected by the votes cast, or in this case, the votes not allowed to be cast. An evolving electoral map could dramatically change the behavior of voters and the parties and the states. The disruption would be all the more acute and could nullify the votes of millions and change the election result, which is the whole point. It's election interference. They just spent millions of dollars to get it to this point. If Section 3 enforcement were attempted after the nation has voted, nothing in the Constitution requires that we endure such chaos, arriving at any time or different times up to and perhaps beyond the inauguration. And so, SCOTUS says, for the reasons given, responsibility for enforcing Section 3 against federal office holders and candidates, it rests with Congress and not the states. Sorry, Jenna. Sorry, Shenna. The judgment of the Colorado Supreme Court, therefore, cannot stand. Now, all 9 members of the court agree with that result, and our colleagues writing separately further agree with many of the reasons this opinion provides and for reaching it. We've got part 1. See the post. We'll read those. So far as we can tell, says the majority, they object only to our taking into account the distinctive way Section 3 works and the fact that Section 5 vests in Congress the power to enforce it. These are not the only reasons states lack the power to enforce this particular constitutional provision with respect to these federal offices, but they are important ones. And it is the combination of all the reasons set forth in this opinion, not as some of our colleagues would have it, just one particular rationale that resolves this case. In our view, each of these reasons is necessary to provide a complete explanation for the judgment that this court unanimously reaches. And so, the judgment of Colorado, the Supreme Court, is reversed, and the mandate shall issue forthwith. It is so ordered. U.S. Supreme Court. Big decision. Obviously, the right decision. Now, let's get some clarification from the other judges. Amy Coney Barrett. She's concurring in part and in the judgment, and she writes a very short little blurb here. Let's see what she wrote. Amy Coney Barrett says, I join parts 1 and 2B of this court's opinion. Now, I agree that the states lack power to enforce Section 3 against the candidates. Now, that principle is sufficient to resolve this case. That's it. So the states can't do anything about it. In other words, they added in, the majority said only Congress can do something about this. She just says, we don't know that only Congress can, but we do know that the states cannot. So maybe courts can, right? Maybe a criminal conviction could get Donald Trump because the holding of the majority is narrower. This suit was brought by the Colorado voters under state law and state court. It does not require us to address the complicated question of whether federal legislation is the exclusive vehicle through the majority which Section 3 can be enforced. And so, again, maybe federal legislation is, maybe it's not. Maybe it's a court ruling, maybe it's not. So there's some risk to the majority opinion because now what if Congress passes something? What if a bunch of Republicans like, yeah, Trump is an insurrectionist all of a sudden, now that I think about it, and they all pass something. Speaker Johnson brings it to the floor. Yeah, you know what? Insurrection. Congress passes it. They throw it over to the senators and the senators stamp off on that, right? Something like that happens. And now the Supreme Court has said, perfect, good, you're good. That's it. So Amy Coney Barrett is saying, I don't know that I would have explicitly said that. Now, the downside with not having an opinion that actually adds any clarity, the majority opinion clearly adds a bunch of clarity. It says only this and this and this. It gives us a very clear test. Congress can enforce it through legislation. If they didn't give us that clarity, then I imagine that they would try this all again, right? They would actually try to use a criminal conviction to disqualify him, or a state legislature would pass a resolution and then they would maybe say that's valid or something. But here she says, states lack power to enforce Section 3. So that would have also precluded that. But you get the point. Now, the majority's choice of a different path leaves the remaining justices with a choice of how to respond. In my judgment, this is not the time to amplify disagreement with stridency. The court has settled a politically charged issue in the volatile season of a presidential election. Particularly in this circumstances, writing on the court should turn the national temperature down, not up. Ah, great. What's the immunity decision going to do? For the present purposes, our differences are far less important than our unanimity. Coney says, all 9 justices agree on the outcome of this case. The message is that an American should take it home. From Amy Coney Barrett. Now, let's see what the left judges say. Kagan, Sotomayor, and Jackson. They say, you know, it's not necessary to decide more to dispose of a case than it is necessary not to decide more. If it is not necessary to decide more to dispose, it is necessary not to decide more. The fundamental principle is called judicial restraint. It's old. So the court is authorized to say what the law is. And they're citing Marbury versus Madison. That's going to be fun when the immunity case comes back. We'll see if they remember that case here in a couple weeks. My guess is no. But today, the court departs from that vital principle. They decided not only just this case, but they also decided challenges that might arise in the future. All right, so if Chutkan convicts and the jurors in D.C. convict Trump of any J6 stuff, which if they can get this trial done before the election, they'll do it, right? That's like, mission 101. And my big concern with that case was that if they said that he was convicted of an insurrection or a related charge, that they would use that as the executing feature for disqualification under the 14th Amendment. They would say, see, we charged him with this insurrection stuff from J6. He got convicted. Boom, he's got to go. So the majority here says, no, that's not good enough. Sorry. The lefty judges, I think, would have allowed that to stay open. Of course, if there was any other mechanism, they would try to squeeze that in before the election, right? They're not just going to wait around. If there's an opportunity to do it, they'll do it. The court is foreclosing a lot of that, and they're still going to try. They're working on legislation. Now, in this case, the court must decide whether Colorado may keep a candidate off the ballot on the ground that he's an oath-breaking insurrectionist and thus disqualified from federal office. Now, allowing Colorado to do so, we agree if Colorado did throw this president off, it would create a chaotic state-by-state patchwork at odds with our nation's federalism principles. How come those lefty law professors couldn't figure that out? That is enough to resolve this case. Like, that's it. That's enough. It would be bedlam. It'd be madness. Now, even though all 9 members of the court agree that this independent and sufficient rationale resolves this case, 5 justices go on. They decide new novel constitution questions to insulate this court and the petitioner from future controversy, right? Because they're going to hit Trump again. Now, although only an individual state's action is at issue here, Colorado, the majority, they opine on which federal actors can enforce Section 3 and how they must do so. And so the majority announces that a disqualification for insurrection can only occur, right? Narrows it. Only, operative word, when Congress enacts a particular kind of legislation. Sorry, Chutkan. Sorry, state legislatures. Sorry, other lawsuits. Sorry, Congress. And it's got to do it very specifically. So like you can't like tuck it into like a spending bill or something. Pursuant to Section 5 of the 14th Amendment. You got to be explicit about it. By doing that, the majority shuts the door on other potential means of federal enforcement, which is a big win for Trump. It's even broader than you think. We cannot join in an opinion that decides momentous and difficult issues unnecessarily, and we therefore concur only in the judgment. So Trump wanted a force field, and he got that from state level attacks, but they also gave him the upgrade against criminal attacks and some other attacks. So it's like super force field level 5. Our Constitution, and they say he only should have got level 1, all right? We didn't need to give him 3, 4, and 5 because he's not under attack from those things right now. Our Constitution leaves some questions to the states while committing others to the federal government. And so they're going to give us a lecture on federalism. States cannot use their control over the ballot to undermine the national government. That's true. State restrictions in that context implicate unique national interests. Again, true. And so the majority, it rests on such principles when it explains why Colorado cannot take the petitioner off the ballot. They say state-by-state resolution of the question of Section 3 issues bars a particular candidate from president from serving. The majority explains would be quite unlikely to yield a uniform answer consistent with the basic principle that the president represents the entire nation. The majority adds, because each state can reach conflicting outcomes, that there are problems with enforcement. Now, the contrary conclusion that a handful of officials in a few states, right, like Jenna or Bellows, the idea that they could pick and decide the nation's next president would be especially surprising. The Reconstruction Amendments were specifically designed to expand federal power and to intrude over state sovereignty. Section 3 marked the first time the Constitution placed substantive limits on state authority to choose its own officials. And so given that context, it would defy logic for Section 3 to give the states brand new powers that Jenna just claimed she had, which she did not. And they're prosecuting people for saying they had power that they did not. So why is Jenna not being indicted for trying to disenfranchise her entire state? Other lawyers who investigated election problems and were wrong about it are being indicted in this country. Many of them. And many of them have taken deals and so on. So if Jenna was mistaken about this, no one's above the law. As she tells us, no one's above the law. So maybe it's time that those new powers aren't actually legitimate, right? They just tried to cobble this together to insurrect the country. No one's above the law. Fair square. Now that provides a secure and sufficient basis to resolve this case. To allow Colorado to take a candidate off would imperil the framers' vision of our country, and the court should have started and ended its opinion with this conclusion. Yet the court continues on to resolve questions that are not before us. In a case involving no federal action whatsoever, the court opines on how this must be enforced. The majority says that they must enact legislation under Section 5 and prescribing the procedures to ascertain what particular individuals should be disqualified. And so they say all this is totally unnecessary. They're gratuitous. All you needed to say was states don't have the power. That's it, but you added in all these other rules. And to start, they say nothing in Section 3's text support their view about how this should operate. This section simply says no person shall hold office, but nothing is an unequivocal bar saying that maybe other mechanisms can't be put in place. In fact, the text goes the other way. It's hard to understand why the Constitution would require a Congress and their supermajority to remove a disqualification if a simple majority could nullify it by just implementing legislation. And similarly, nothing else in the rest of the 14th Amendment supports the majority's view. Section 5 gives Congress the power, and all Reconstruction amendments say this, and so none of this gives them the right to extend this beyond. So the majority is left with next to no support for its requirement that only Congress can do this. Once again, even petitioners' lawyers distance themselves from fully embracing this case as deciding what Section 3 means. And so ultimately, under the guise of providing a more complete explanation for the judgment, they add in a bunch of other stuff. It forecloses judicial enforcement of that provision. There you go. Such as what might occur when a party is prosecuted. There you go. There it is. It forecloses judicial enforcement of Section 3. Such might occur when a party is prosecuted by an insurrectionist and raises a defense on that score. The majority further holds that any legislation to enforce the provision must prescribe certain procedures, ruling out enforcement under the law, and by resolving all of this, they attempt to insulate all alleged insurrectionists from the future challenges to their holding federal office. So they're very bitter that criminal prosecutions will be foreclosed. See that right there? The courts, right, can't enforce that provision. Yep. If a party's prosecuted by an insurrectionist and raises a defense on that score. So interesting. Now, what it does today, the court should have left undone, is how they close. They say the court today needed to resolve only a single question: whether an individual state may keep a candidate found to have engaged in insurrection off its ballot. Now, the majority resolves a lot more than they needed to. It reaches out to decide Section 3 questions that are not even before us right now. And in a sensitive case, crying out for judicial restraint, it abandons that course. Section 3 serves an important, though rarely needed, role in our democracy. The American people have, says the left judges, the power to vote for and elect candidates for national office. Now, the men who drafted that, however, had concerns about insurrection, and they wanted to ensure that insurrectionists would not return to prominent roles. Today, the majority goes beyond the necessities to how they can limit Section 3 to bar an oath-breaking insurrectionist from becoming president. And although we agree Colorado cannot enforce this, we protest the majority's effort to use this case to define the limits of federal enforcement of that provision. So if Jack Smith finds Trump guilty, or Chutkan doesn't sound like that's going to apply. And even the left is acknowledging that. Because we would decide only the issues before us, we concur only in judgment. So 9-0, my friends, and it's actually, I think, even broader than even people on the left were explaining. It's saying, look, 14th Amendment doesn't apply. It's a kind of a jurisdictional concern, right? States can't do this. Only Congress can do it. So they're not even reaching the question of insurrection. Just, you don't have the right to enforce this. This is how it should be done. And it forecloses other areas where they might try to lob new attacks, which is trying to remove him from the ballot based on a criminal conviction. So it's a tremendous victory, actually, even broader than I had thought. Even the lefty judges are saying it's way too broad, right? We wanted these other attack vectors, and now we don't have them. So they're not going to give up there. Okay, the DOJ is also digging into this. He's talking about voting rights and voting attacks and so on. But this was a curious thread. There was a question about whether there was an actual dissent in here. So Mark Joseph Stern, he says, if you double click where it says JJ at the top and then copy and paste it, the line reads Sotomayor concurring in part and dissenting in part. So there might have actually been a dissent in here. And someone said it was actually in the metadata. So they actually left in the header of the document. It says right here, Sotomayor concurring in part and dissenting in part. And we thought that she might be the lone one, right? It was Kagan and Jackson who were kind of on with the majority. And Sotomayor felt like she may have not been on the same team. But they don't want to be on the wrong side of history here. The Supreme Court is unlike the lower courts in that, law school students are going to read their opinions for the next, several decades. So they want their legacy to matter. And Sotomayor was not going to be the odd one out, right? It's not going to be 8-1 because she's going to be the only one that is seemingly not getting it. Don't want to be the lone bozo who's like, how do I put this in here? And so she joins in. There may have been a dissent, but she, to her credit, seems like she made this a uniform decision. Now, I think that there are a lot of benefits from this decision that reaffirm that immunity is the next one down the pike. Now, I don't know if that's going to be a 9-0. I doubt it because there are some more complex issues there. But this was something that was seemingly obvious, and a lot of people couldn't figure it out. So, as I said earlier, the Democrats are not just going to, give up. They've got a lot of other attack vectors, and they're now going directly to the mechanisms of of elections in the first place. This was Merrick Garland talking about how certain individuals are under attack and they're going to, I guess, help people get to go vote without things like voter ID, voter registration specifics are all going to be, now considered attack vectors for certain communities, and the DOJ is going to work to reverse those.
The right vote is still under attack. And that is why the Justice Department is fighting back. That is why one of the first things I did when I came into office was to double the size of the voting section of the Civil Rights Division. That is why we are challenging efforts by states and jurisdictions to implement discriminatory, burdensome, and unnecessary restrictions on access to the ballot, including those related to mail-in voting, the use of drop boxes, and voter ID requirements. That is why we are working to block the adoption of discriminatory redistricting plans that dilute the vote of black voters and other voters of color.
All right, so you're going to see they're going to water down a bunch of voter integrity requirements. They don't really care who votes, and it's all because of racism and so on. But the efforts continue. Psaki is also very upset. She came out over the weekend before the Supreme Court opinion came out, but she's upset about the Supreme Court and the immunity issue, okay? They needed all of these legal maneuvers to win, or else they're in hot water. And you can see even her, imagery on her show. It's Trump plus these 9 justices, like he owns them all. She's very upset with SCOTUS. Let's listen.
Since Donald Trump's third Supreme Court nominee was confirmed just weeks before the 2020 election, there has been this big question hanging out there. Will they help him? And if so, when will they help him? Well, this week, the Supreme Court announced they were taking up Trump's absurd claim of presidential immunity. And in turn, they granted him the thing he covets the most: more time.
It's called due process, Jen. This case has been going at rapid speed. You know that. We've covered that here. There is no reason at all this should have gone this fast.
Because when you're running for president to stay out of prison, you sure don't want to stand trial before Election Day. And by taking up this case, the court has now raised the real prospect that he may not. I mean, for reasons that remain completely unclear, they will not even hear oral arguments until a full 7 weeks from now. So Trump's election interference trial, that at one point, by the way, was scheduled to start tomorrow, is now being punted months down the calendar. And yes, I know that the wheels...
Because he appealed, and because this case has already been accelerated to an insane degree. There's 13 million pages of discovery that Chutkan said you didn't even need to worry about.
Of justice can move slowly. I have made this point myself many times. But guess what? The Supreme Court can move very quickly when it wants to. I'm going to give you a few examples. Let's take Bush v. Gore in 2000. The court decided the election in 3 days. You don't need to look even that far back.
Oh my gosh, that's such a bad example, because the election was already underway and they were counting the ballots in real time. All right, so that's enough, Jen Psaki. But she, of course, wants them to accelerate this because she wants all of these convictions to happen so that they can try to disqualify him based on his convictions. But SCOTUS just said those are not disqualifying. So even if he does get convicted, right, even if he comes back, let's say the Supreme Court says there is no immunity, election J6 litigation is back on, okay, he gets convicted now. What are they going to do with that? They'll take that felony conviction. They'll probably try to parlay it into legislation, right? They'll try to say Trump is now a convicted felon and he got convicted of the J6 charges, if they can even get the trial back on track before the election happens. And they're going to try so hard. But even now, right, after this ruling came out, doesn't matter. The criminal conviction doesn't matter. The only way that Trump can be removed from the ballot, according to SCOTUS, is by Congress, an act of the federal Congress. No more Shenna Bellows out of Maine. No more Crazy Eyes Griswold out of Colorado. Joycelyn Benson and all the rest of them, they're all trying their different attacks in Illinois and so on. But they all lose. It's got to go through Congress. And of course, you know how hard it is for Congress to pass anything. And Speaker Johnson is in control of the House. He would bring anything like this to the floor is very, very low. So very big victory today. 9-0 from the Supreme Court. A lot of lefty law professors we're going to talk about in the next segment, all melting down. And so big victory, of course. Been waiting for this one. We're also waiting for the immunity oral arguments to come, and we're waiting for that decision as well. We're covering all the Trump litigation here, my friend. So make sure you're subscribed wherever it is you're watching this. Thanks for liking the video. Thanks for checking out some of the links down in the description below. Watchingthewatchers.locals.com is where we do our member-only streams in the morning, and we'd love to see you over there because we got a lot to talk about. And we'll see you back here on the next one.